Okay, it's time now. Um, but please, can we just give like 2 minutes and see if we have people join us? Okay, thank you. Okay, okay. We have some people here already, so we're just going to go straight to the topic of today. You're welcome, everybody. I see Mr. Clarence, I see Queen. Thank you so much for joining us. And our beautiful host and presenter, thank you too for joining us today. You're welcome, everybody. We have a very interesting topic today. But before we go into that, I would like to briefly introduce Barrister Lucy. Barrister Lucy is a senior associate and managing lawyer of the Family Law Division at Osuji and Smith Lawyers. She practices family law, divorce, employment, labor law, and civic litigation. She also serves as a board chair at and a volunteer lawyer at Ruth House. Barrister Lucy is an advocate for women, children, and families affected by family violence. Barrister Lucy was recognized as the 2025 Professional of the Year by the Afro-Caribbean communities. Thank you so much, Barrister Lucy. You're such a blessing to this generation. Thank you for all the things you achieve and do for families undergoing domestic violence. We are sincerely appreciative of you. Thank you so much. The topic for today is an overview of the new family court system, breakdown of the steps and different phases, documents involved, and how to satisfy the various requirements. So, Barrister Lucy, you have the floor to dish to us everything we need to know about this topic today. So I'll just let you do the introduction and take us into everything that you have for us today. Thank you.
Thank you so much, Victoria. It's always a pleasure to have you host. And thank you for everyone who has joined today. It is July 16, 2026. This is my birthday month, so I'm always super pumped and energetic in my birthday month. And of course, I'm always excited to meet with everyone and to share some information, exchange knowledge for our lunch and learn as always.
Barrister Lucy, can I do something quickly? So please,
Yes.
can we all unmute and say happy birthday to Barrister Lucy? She comes here every time to host. That's a beautiful thing. So I think let's just take a second and say happy birthday. Happy birthday
Happy
to
birthday.
Happy
you.
birthday.
Happy birthday to
Long
you.
life and success.
Amen. Amen. Amen.
Happy birthday, Barrister Lucy.
Thank you so much, Queen. Thank you, Mr. Winter. Thank you, Victoria.
You're welcome. You're
Yes,
welcome.
I really had a good celebration with beautiful flowers from Ruth's house. So thank you guys
You're
again.
welcome. Okay.
Now, the topic that we're discussing today is very fundamental because it deals with a big change in the family court system in the entire province of Alberta. For those who are not familiar with the legislature or the court systems in Canada, family law is more provincial than federal. Most of the statutory provisions that we rely on in terms of assessing parenting, child support, spousal support, and all of those things are more provincial. The federal statute that we rely on is the Divorce Act, but then we cannot deny the fact that not all relationships end in marriage and not all children or separation issues.
Hello?
Yeah, I was.
Okay, we can hear you now.
Oh, could you not hear me before?
Yeah, just go on. It was unmuted for a while, but we can hear you.
Okay. So today our conversation is based on the changes that were applicable to the family court system in Alberta, and some discussions had happened about it in the later part of 2025. However, those changes became effective as of January 2nd, 2026. And this is precisely or specific to the province of Alberta. Given that we do reside in Alberta, we need to highlight those changes for our own province. But if you are in Ontario or BC at this point, you may not have been affected by those. So you may need to speak to a lawyer from your particular province to assist you in the future. To help create some visuals and that ongoing understanding of my discussion today, I did like to share some documents. So I'm going to send a request to you, Victoria. I think you have to approve that.
Yeah, it's granted.
Perfect. You guys will have to bear with me. I'm not very savvy with on my calendar instead. Right. Okay. I have 4 documents, but then they're brief. We might not go through them today, but the information will be circulated by Ruth's House. If you do have questions, please reach out to them. They will provide you with documentation. And if you feel like you need further assistance, they can always connect you with me or another lawyer that is affiliated with Ruth's House. When it comes to this new process, it's called the Family Focus Protocol and FFP. So you hear lawyers talk about FFP a lot. That's just the acronym for the Family Focus Protocol. It is, again, the system that was implemented starting January this year. It didn't bring like a totally new system, but again, they had to rename it because new processes have been put in place. And so if you ever find yourself in the family court system in Alberta right now, you will say, okay, I'm going through the family focus protocol because that's what the court system is called. And this material was compiled by the judiciary, which is the bench, so judges and justices, together with input from lawyers. And the materials were also produced following town hall meetings in the entire legal profession, so you can rely on this material. Another thing that I will note is that you can find this material on the Court of King's Bench of Alberta website. So it's not information that I created. I'm just here to break it down and to interpret it. Under the Family Focus Protocol, we do have 3 categories of matters. As we see it listed here, regular family process, meaning that you're just going through your separation and you're following the regular step-by-step in the separation process and the divorce process. But then we have desk processes. Desk means that you are not required to make appearances in court or to make oral applications in court. There are certain things that you can get from the court, by the judge signing it without actually appearing. When it comes to, for example, if you want an order for disclosure because someone is failing to disclose their finances, there are forms that you can just fill out and submit to the court in written application rather than making an appearance by scheduling a court appearance. That saves time. You don't have to miss work to attend court. And if you need advice on how to go about those things, you can always reach out later. Urgent processes. Now, that's still part of the separation and divorce process. It's just that there's circumstances where things become very urgent. And of course, the court cannot follow the normal timeline. So in those urgent situations, they will give you exceptions. For example, you have your children in Alberta with you in Calgary, or a child, and the other side picks up the child from school without your knowledge, and there is a restraining order or something preventing them from seeing that child, then before you even are able to contact the police, they have already left to Ontario with the child, or who knows, gone outside of Canada with the child. That is an urgent situation because it could be considered kidnapping, and the police will have to get involved right away if the child is still in the country. But if the child still has been taken outside of the country, then you know that it has escalated into international territories. And so we're talking about the Hague Convention, we're talking about international authorities who are, going to be intervening to bring that child back to Canada. And those are urgent situations because it's life-threatening, it's immediate, it requires like right now solutions. Yeah. Or another example is this. You had to like immediately separate because, again, due to family violence situations. So in situations that you don't plan ahead of time, it's something that just happens and you had to get away immediately and you need an urgent relief, for example, child support or spousal support. If those circumstances are shown to be urgent and something that you had no knowledge of and they're outside your control, of course, the court could make an exception to you in terms of timeline. But it involves an application process. We do have a form for that. It's a 2-page form. You just have to complete it. If you're approved for urgent chambers, you'll be scheduled right away, like immediately. So you will not have to follow the normal timeline. The next thing is just a breakdown of the step-by-step process. Again, if you intend to use the family court system in Alberta, unfortunately, you have to go through the system because this is the only system. The first thing will be looking at whether, based on your circumstances, you have complied with what we call the mandatory requirements. Before you start an action in court, in the family court, you must complete your mandatory requirements based on your circumstances. And the first requirement is the parenting after separation e-court certificate. You guys may have heard me talk about it before. You may have heard about it from different lawyers or just, participating again in the court system. But what that is a 2-hour course or so. And every parent who has a child under the age of 18, you have to complete that course. It's required of both parents, so it's not one person doing it. Both parties have to do it. You will be issued a certificate. It is a free program that is offered by the province of Alberta, so you don't have to be charged for it or you don't have to pay for it. It is an online course, which makes it again convenient. You can do it at any time of the day at your own convenience. Once you do that, you get your certificate issued, you have proof of completion, and that certificate is valid for up to 2 years. So if you continue through the court system, you will not have to take it again unless the 2 years has expired. And if, say, for example, your separation happened when your children were like 17, it means that they're going to be 18 in 1 year, which means once they turn 18, your certificate does not really become applicable because, again, it's for children for whom parenting arrangements are being put in place, and you cannot put a parenting arrangement or decision-making arrangement for an adult child who is 18 years and older. The second thing is Alternative Dispute Resolution, ADR. Most of us are familiar with ADR acronym. It just, the things that are part of or considered ADR processes include mediation by a private mediator. You also have community mediation, which are free or subsidized. But even through the court, we have mediative measures, and I'm going to talk about that right away. One of the mediative measures that we have through the court is what we call resolution counsel. Resolution counsels are lawyers. They are just very experienced lawyers. A lawyer could apply to become a resolution counsel. If they go through the evaluation process and they approve, they become an officer of the court and they work for the court system. I'm not a resolution counsel because I'm in private practice, but if, say, for example, I was to become a resolution counsel, I will make an application and it will become a job offer. That will be my role going on, like moving forward. Resolution counsel processes are free, but you don't have to pay for it, but you get exactly what a lawyer will give you, that representation, that guidance, that mitigation, the mediative and intervention that you need in your matter. They will guide you step by step on what to do, how to compile your documents. They will communicate between the parties. They will schedule meetings for you too. They will meet with you, whether in person or virtually. And you will not have to take on that responsibility of doing things for yourself because you have really high-end guidance, and they are very qualified and competent in the law because they're lawyers, right? They don't just charge you for the services. But then before you can go through the resolution council and use the services, you have to apply for it. This is the form. I have the form here. It says request for meeting with resolution council. It's a desk application again, meaning you can complete it, go to the courthouse, ask where you can drop it off. Someone will show you. You don't need to appear before a judge to make an application. You just need to submit the documents. It will be evaluated and you will get a response by email. If you are approved, they will schedule a meeting and take on that, step-by-step approach with you. But there are conditions for that. For you to qualify for a resolution council meeting, one, if you have to be self-represented. And the reason why we do lunch and learns is because we want to provide information to those individuals who cannot immediately afford to hire a lawyer and they need some form of guidance, if they're starting an action or they're trying to think about it or maybe defending an action. So this is important information for that category of individuals and for that audience again, because it's financially free. It's you get the same guidance that you get from paying a lawyer. Another thing is that your income has to be less than 90,000 and you have to live in Alberta. So if you make more than 90,000, of course, your income is considered high based on the tax bracket, and you cannot use a free service that is being sponsored by, the judiciary system. And you will not qualify. But if your income is less than 90,000 and you don't have a lawyer, you definitely qualify to use resolution counsel. So very useful information. Plus, there is no, they don't give you a strict timeline that, oh, you must only use them for 3 months, or no, it's an ongoing process. Once they guide you through and get to a meeting, if the meeting is not successful, they can schedule another one. And I believe that you can schedule up to 3 meetings, like a settlement meeting with them. If you and the other person come to terms of agreement, they will prepare a court order with those terms. So think about you going to pay a mediator when you have a free mediator at the courthouse. Those are the importance of having a resolution council meeting. And that information is available on the Court of King's Bench website. If you don't know how to get there, you can Google the Court of King's Bench, but if you just need directions again, you can reach out to Ruth's house for that information. They will be able to guide you on it. Back to our step-by-step. So We're still on the mandatory requirements. We've talked about parenting after separation. We've talked about alternative dispute resolution. We've now moved to financial disclosure. Financial disclosure is only important if you're dealing with child support, or spousal support, or partner support, or property. If you are not having any property items to deal with and you don't have any children of the relationship or the marriage, then you don't have to deal with financial disclosure, and you can get a waiver for that, meaning that they'll allow you to move on without fulfilling those requirements. One important resource that has now become readily available at the courthouse is what we call the family counselors. I do remember a few sessions ago, I emphasized on the use of family counselors. We live in a society where most people complain that they cannot afford legal services, but then they don't make an effort to know which free services are available, even through the court system. And the good thing about Alberta, I can't speak for the entire Canada, but the good thing about the province of Alberta judiciary system is that there are a lot of free resources that can help you escape the financial burden of having a lawyer. In Calgary, I can say the cheapest lawyer that you get is maybe $300 per hour. And sometimes going that low may also come with the consequence of not having proper legal representation. So if you cannot afford it at the time that you need it, why not use the free resources that you have? Family counselors, you don't pay to them. They'll never ask you for money. They're paid by the judiciary system, and they are readily available to guide you again step by step on what to do in terms of the court documents, in terms of filing court documents, serving them, putting everything together, scheduling hearings. So please, 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 if you have questions or doubts on how to get those free resources, please reach out to Ruth's house or go to the courthouse someday and just explore it. You're paying for it anyway with your tax dollars, so you might as well explore it and use it. Now, once your mandatory requirements have been compiled and they look satisfactory, you will be able to get an approval that your package is complete. And that approval will come from the case management office. This is all structured. There is no way you're going to miss any part of it because, again, you will get guidance from the court. So that confusion will be reduced. And of course, they are knowledgeable on what they do. Step 2 is starting your action. If you are married, the new court system insists that if you were in a marriage, meaning that you have a certificate of marriage and now you're separated, you have to go through a divorce because the divorce actions in the court have a different court file number compared to those who were not divorced. In the past, you could say, I don't want to get a divorce right now. We're just separated. I want to deal with parenting, child support, spousal. I will deal with a divorce. Then you have people who dealt with parenting and their children are grown 50 years ago, but they're not divorced. They never got a divorce judgment because they never addressed that aspect of it. But one thing that we have to realize is that when there's a separation in a marriage, the main thing is a divorce judgment because when you got married, you got a certificate of marriage. So now that you're separated and you're going to get divorced, you need a certificate of divorce. That is, once it's granted, is sent to the registry and your status or your marital status is updated. It also contributes to Statistics Canada because then they know the number of married people and non-married people and all of that. But for record keeping purposes, they insist on these things as well. With this new system, you cannot leave one thing and deal with another and say, I'll come back to this. You have to deal with it together. They used to find that people spend 10 years in the system going one issue, they'll do one issue today, and then they come back 2 years after and deal with a second issue. It's kind of burdening for the justice system because, again, we don't pay judges, they are paid, a salary by our province. So if we are not using that time wisely, then, that time is money. So with this new system, they ensure that the structure, if you're married, you have a marriage certificate and you decide you don't want to be married anymore, you're going to go through a divorce, which means you're starting your action in court by way of what we call a statement of claim for divorce. And then if you have property, you'll be a statement of claim for divorce and division of property. Those forms are available on the Court of King's Bench website. You cannot miss it. But if you have doubts on how to access them, you can reach out to Ruth's house. They'll have a lot of guidance for you because they have me, they have other lawyers on the roster who can assist with that process. When you file your commencement document in step 2, you will now have to serve it. Filing that document doesn't give you a court date, but it gives you like a court file number. When you file it now, you cannot serve it yourself on the other side. You need to use a process server with a professional, or if you have a relative who is over the age of 18, so that 18 years and older, they can help you to serve the document by handing it to the other side, taking a picture, and then preparing an affidavit of service to say on this day, at this time, at this place, I gave this document to Victoria, I gave this document to Lucy. Yes, and there's proof of service. That way you can move forward. After you file and serve your commencement documents, then you now move into the actual court system, the FFP system, by, we have what we call the request for mandatory intake triage. You see, they say MIT, it means mandatory intake triage. There are 2 documents that you have to prepare in that package. They are found on the court website, step by step. You cannot miss it. But if you have any doubts again, please reach out to Ruth's house and they will help get that information for you. Once you file your mandatory intake triage document package, it will be reviewed by case management office. They will now tell you, it looks fine, this is what you need to do. If you need any revisions to it, once it's approved, they'll give you a check of approval by email, and then you will now proceed to serve your documents on the other side. The good thing about this step 3 is that it's not by physical service. You can do it by email. It's easy. You just email the other side document saying, please find it attached and everything. At this point, you still don't have a court date. But once you have served, you have to go back to CMO and say, I have served. And then they'll be like, which day did you serve? You tell them. Then they give you a check mark of service. And at that point, you now have a link to book a conference with the judge. One thing, so MIT conference is in step 5. One good thing about this system that I find is this. When you start through the system, you're assigned a judge, a justice, and that justice is available to you from the beginning to the end. The good part about that is if you need to request a meeting with the justice, you can do that by email. If you're self-represented, you should be drafting your emails politely. Some people talk to judges as though they're talking to a child in the classroom. It's very inappropriate, it's disrespectful, and as much as those judges are humans like us, or maybe some of us are older than them, you have to respect the office because again, they have the authority to decide over your matter. And I know that in Canada, there's a freedom of speech, there's freedom of interaction and stuff. That level of freedom that we may not even experience from the different countries that we're coming from. But we have to remember that these judges that are put in place, they deserve the respect. They have earned it through education and experiences, and they have the authority, again, to decide on your matter. So as much as you have the rights in Canada to communicate in the way that you want to, you have to remember the authority that they have, and they could exercise those authorities over you. So polite communications with judges is very important. But the judge that is assigned to your matter, you become aware of them. You can email them and say, good afternoon, Justice, blah, blah, blah. I would like to request a meeting with you. You have to copy the other person though. But before now, we didn't have this kind of access, and that judge is with you. So they are not passing on your matter to another judge every time you go to a courtroom or every time you have a court process. It's the same judge who is taking you through. If something is missing, they're telling you what is missing. They're guiding you on the next steps. So it's like you having a godfather or a godmother just taking you through life with that guidance, especially if you're self-represented. And even if you have a lawyer, it's the same process because everyone has to go through that process. In terms of importance too, is regarding timeline. If you have that level of access, it also reduces wait times, it reduces anxiety, it reduces confusion, which is, the purpose of this new FFP program. The first MIT conference is what we call mandatory intake triage conference. It's between you, the judge, and the other person. It's in person, it's for an hour, 1 hour free with the judge. And you just have a discussion. It's like a family meeting. You just sit there, you talk about the case, you talk about the issues, you talk about each side's proposition. If you have lawyers, of course, your lawyers are coordinating this and you don't have to worry about it yourself. But because you're going to be present during that conference, you can speak directly to the judge. There is nothing more pleasing than a party being able to talk directly to the judge, say their point of view, describe the circumstances in the way that they experienced it. My client could describe to me the experience of domestic violence and abuse, but the way that I translate it in documents or I present it in my submissions to the court will not carry the same emotions that the person who experienced it will. So that's an advantage of you being present, listening to what the court is saying, and communicating your voice in that same process. Once the conference is done, the judge will give directions and guidance for next steps. If you are ready, the court will send you to the settlement meeting, which is the next step. We can see it here on item number 6, settlement meeting. To be honest with you, when I saw this in our first town hall meeting in September 2025, I was very excited as a family lawyer in Alberta because in the former system, we didn't have a structured settlement meeting or a court-mandated settlement meeting in family law. We had that in employment and civil litigation, but we didn't have that in family law. Now we have it, which means that, again, you don't have to beg the other person to come to the settlement table with you. You don't have to cajole them. You don't have to bribe them with anything. They can't say, oh, you give me this, then I'll consider, discussing settlement with you. As a lawyer, I don't have to convince them to come to the table. I know that at some point they will come to the table whether or not they like it, right? And if they don't, well, they're missing out because then they will not have the opportunity to get that voice or proposition before the court. But if you see something like this, the settlement conference is again for an hour or more. So you have the opportunity to sit before the justice, whether or not you have a lawyer, and to say, this is what I'm proposing on the issue of parenting, child support, spousal property, and you're not paying. So when you compare this to, a mediator that you could pay or a lawyer that you have to pay to help you through this, you're getting it for free, which is another plus. If the settlement meeting is successful, terms of agreement will be compiled and will be circulated to the parties to note the agreements between the parties. There are forms that, of course, are applicable. You'll be informed of those forms, you complete them and stuff. But not all matters settle because, of course, again, we're humans. Sometimes we cannot put aside our grudges and just focus on the issues and things that are important. There is still that urge to fight and struggle and all of that. If there's no settlement, the judge can make a decision to say that, you know what, take a break today. I'll meet with you guys again.
Okay.
Just because judges are trained, I mean, they're very smart. And the way that the judges are, appointed in Canada is a little different from different countries, because in Canada you have to be a lawyer and then growing your experience, and eventually you could be appointed as a judge or a justice, right? So the next 20 years, I could become a justice of, of the court. And so you already have that understanding that, one, they have had the experience of being a lawyer and the struggles of being a lawyer and interacting with the society and clients and understanding people's circumstances, which means they're not just going to a school for judges and then graduating and becoming a judge. No, they've actually gone through the process of handling cases over time and so many years before they can sit on the bench to make decisions, which makes them very competent and knowledgeable in most areas of practice. But again, if a matter doesn't settle, the judge can schedule another meeting just to give you a second chance at settlement. But if it's not settling, of course, the judge cannot force you to settle. And that's when the matter will be looked at for trial preparation.
Okay.
At that point, directions will be put in place. Okay, that has brought us to the end of the breakdown. This is a lot of information today, but if you have any doubts again, please don't hesitate to reach out. Someone is always willing to help you with these interpretations so that you don't get frustrated or overwhelmed with the documentation. We've already discussed Resolution Council, which is a free service. And then this is just a repetition of what I presented before. But here you have more of a graph, which, again, just expands, in picture form, exactly step by step. You see here, mandatory requirements, step 1, right? You see filing of documents, step 2, case management reviews, approves, and then you get to MIT conference, and then you get to settlement conference, and trial preparation conference, and then a trial. Ruth House can share this with you if you reach out to them. You put this on your wall if you're going through a separation or a divorce proceeding, and you say, okay, at what point do I contact Ruth House for clarifications? At what point do I contact Lucy for clarifications?
Okay.
That is what I have for today, just so that I'm not pouring a lot of information in one session, but I will take questions at this time.
Barrister Lucy, thank you so very much. I'm sure we now have better understanding of the new family court system. Thank you for breaking this down and making us understand it better. We are grateful. Thank you so much. So now we'll dive into questions and answer section. I have a few questions here, and then I would leave the floor open for others. In case you have a question here, prepare your question to ask after mine, or if you're not so comfortable speaking, you can just drop it in the chat, and then I would read it out to her to get your answers. So, Barrister Lucy, the first question I have here is how does the new family court system better protect survivors of domestic violence and ensure their safety throughout the legal process?
I like that question, because again, you guys know when it comes to family violence and abuse, it's a no-no for me. This system provides structure, and the reason why that structure was discussed before this system was implemented is because of the experiences that lawyers and judges have been seeing in the family court system. When someone is going through a separation, particularly a separation that resulted from the experience of violence in the relationship, they're already dealing with psychological, emotional, and mental challenges, trauma and all of that. For them now to have struggles with understanding the system is very frustrating, and that's why most people give up. I've seen a lot of women who, for the lack of money or lack of energy, they don't just have the strength to fight anymore, and they're like, Lucy, I don't have the power, I don't have the strength, I've been through a lot, let him go, let him take the kids, let everything just stay, I don't care anymore. But with such structure in the system, as you can see, it's a step-by-step thing. And not just the structure there in terms of how you go through it, but also the assistance that you get through that process. If you have a counselor who is guiding you, you are not alone. So even if you don't have a lawyer, it already helps you with that mental stability, and you can focus on getting your voice. So for the individuals who experience family violence in a situation like this and are going through this separation, it's already elevating that stress of now going through the process of getting your story before the court. That's the assistance, first of all, because unfortunately the experience already happened and it cannot be taken away. But what needs to be done is to mitigate or reduce the time that you spend, through the process, and how fast you can get your voice before a judge, and that judge can make a decision that will help you moving forward, because that's the only way the court can intervene. You have to get before them before they can intervene. So the process of getting before them is what they are trying to help with, and that's the focus of this new system, as you can tell from the name.
Okay.
In the meantime, while you're going through and trying to figure out your filings and documentation and all of that, we have resources. Again, Roots House is here, counseling services, shelter services, rehabilitation services. They can help you with emergency protection orders. They can help you restraining orders. Those are things that you need in the interim to provide you with that safety measure so that you can stay calm and collected and think of going through the court system, because the court system does not have like a right now situation for you. The only thing they can do is make an order that will help you get to safety. For example, emergency protection order. If you are granted that, it gets you to safety because it keeps the other person away from you. They cannot come close to you. If they come close to you, they get arrested and it becomes a criminal matter, which creates a record on their profile. So most of them are learning lessons. Previously people used to say, oh, it's like, I'll just break it. If you break it, it becomes a criminal matter, because even though it's granted by the family court, breach of that order becomes a criminal matter and you get arrested right away and it goes on your record. So you don't want that, which means you have to comply with it. That's one protection the court can give you. But the court cannot really do a lot of things when it comes to like the person now intervention, because again, the court is a system. It's not a human being. However, while you're going through the family court system, we have measures that are available for the children. If you have severe concerns that them being in the care of the other person is not in their best interest, we have the PN 7 and 8, which deals again with parenting assessments. You can request for that. The court would grant it if there's evidence to substantiate the fact that it's needed. And while that is being done, the children will not be put in the care of that person. The court can also order for anger management and counseling classes. So this is not just the person deciding to do it. This is the judge saying that you need to do it. And until you complete it and show that it's improvement, you're not going to get access to your child or your children. Again, it provides the safety for the children. It provides safety for the parents who has those concerns, right? In relation to the family home, so for example, if there's a protection order and the other person is removed, you can get what we call exclusive possession of the home. But even before you get into obtaining an exclusive possession order, you already have the protection order which keeps that person away from you. They're not going to come close to the home for up to 1 year. And you can maintain some peace in the home, put your thoughts together, care for your children, care for yourself, take time to heal, from the trauma, and then be able to get the strength to fight this person. We do have those resources, but the most important resources that we have, even through the court system, are those psychological or mental health services that are available to you. When you speak to a family counselor, they can definitely direct you on what to do and how to get those services. I did share a huge document in my last session about all those resources. Look at them. There is something there for somebody. But you have Roots House again. Roots House has a spread of services in addition to what we have for General Calgary. So that's what I have to say.
Okay, thank you so much, Barrister Lucy. Thank you so much. There's another question here. What are the common mistakes presented individuals make during early stages of the new family court process, and how are they able to avoid them? And also, this is really like a two-in-one question. In a case where a family already have started the court process for a divorce, and halfway through it, they want to like stop. Maybe there's like a discussion between both partners, and they want to go back to status quo. In that case, is there like a reverse? That's what I was saying. Is there like a reverse protection or system for people like that? Have you had a situation where family already started this process and they come to you and say, "Oh, we don't want again, we want to be together"?
You want to reconcile.
Yes, the new family court
Yeah.
system. Is there like a system for such situation too?
I'll start with the second question, which relates to reconciliation. Now, at every point in time, you can reconcile. If you look at the statement of claim for divorce, it talks about reconciliation, the possibility of reconciliation. Because again, we're in Canada, which is very family oriented. And so when it comes to reuniting families, that's a priority. And also Roots House, most of our services in Roots House are targeted to reunite, to heal, to rehabilitate, which means that we are family oriented. We're not here to separate people. But if there needs to be like an interim separation, we'll kind of come to help with that, right? However, if parties start a divorce process, say the wife started it or the husband started it, or they started it together and they're amicable, saying, now we want to get divorced, and they're halfway, they're like, you know what? We've thought about it, we've had interventions, we want to reconcile. You can reconcile anytime and you can withdraw from the system. If you've already filed your commencement document, it doesn't stop you from reconciling. Filing a statement of claim is just to commence an action. But if you don't want to go through it, you don't have to. You can abandon it, you can withdraw it, you can discontinue the action.
Okay.
All of those things are available for sure.
All right.
No one is going to push you or pressure you into going through something that you don't want to. However, one important information that we always need, and even if you're self-rep, you always need it through the separation and divorce process, is the separation date, because it's important in deciding when child support payments start, in calculating spousal support, in calculating property division in terms of asset and debt, because we need the date that your relationship or you stop being having that representation of spouse or partner, because from that day you're on your own, the other person is on their own. You are not joined together anymore, which means that if you are separated in August, child support is supposed to start in September. So one thing that will always ask you, the first thing, if you meet with me, the first thing I ask you is, what was your separation date? Because I will need to know when the liability for child support started, or when the liability for spousal support started. If you're staying in the same house and you're the one paying the mortgage, I'll ask you, when was your separation day? You tell me, oh, we separated August 26th. I was like, okay, it means that starting September 1st, the other person was supposed to be paying you 50% of the mortgage, because at that point, you're no longer the husband. You cannot be responsible for the family. You are no longer the wife. You cannot be responsible for the family. You guys are like roommates. And if they did not pay you that 50% of the share of the expenses for the house, it means they owe you, which means that at the time when we're dividing property, we're calculating all those payments that you did after the separation date, and you have to be reimbursed for them. So those are the importance of separation date. But if you reconcile and you do reconcile for 90 days or more, so 3 months, the initial separation date goes out the window.
Okay.
So if you reconcile and then you break up again, it's like you're starting afresh. You cannot rely on the previous original separation date.
Okay.
In terms of mistakes that self-reps do through the family court system in general, I feel like most of them, because maybe again from the circumstances of the separation at that time, they don't have like a clear thinking process, they fail to get a startup guidance. I always suggest that you get guidance at the beginning. When you get guidance at the beginning in any situation, it always helps you to maneuver through the process quicker and easier. But if you start something, then try to now make efforts to understand it. It's confusing because you're already part of it. If you are to meet with a lawyer quickly before you start a process, you will get the guidance that you need through a consultation. We talked about the Calgary Legal Guidance the last session. It's a free service and you can get up to an hour of free legal advice. Ruth's House is here. It has lawyers that are connected with them, like myself, who are able to just assist you briefly, right? So getting it at the start is very important. Don't get fueled by your anger. Oh, she sent me document. Oh, he sent me document. I will show him what you can't show somebody what you don't know. For you to be able to prove a point, you need the knowledge, you need the tools, you need the understanding, and you can only get that understanding by getting guidance, because even lawyers are confused by this process. So imagine a self-represented party. I'm sure that if you look at the documents, there's some legalities that you will not understand. How do you go through something like that successfully? And that is not your area of expertise, right? If I'm sick, I go to a doctor. I will not diagnose myself because it's not my area of expertise. So always making that attempt or effort to get the initial guidance is important in all circumstances.
Thank you so much. Thank you so much, Barrister Lucy. So I'll make the floor open. If you have any question here and you need to ask, please, you can go ahead, unmute yourself and ask your question. Nobody?
Hi, I do have a question, please.
You're fine.
Okay, sorry, my daughter is here. Please ignore her.
Fine.
For someone who has been separated for over a year, I wanted to know, is it okay to fight for child custody first before filing for divorce, or you have to fight for divorce first and have it finalized before going over for child custody, or both of them is intertwined? I've been confused about that.
Mhm.
Yeah, that's my question.
Thank you for that question, Queen. Your third option answer is the correct one. When you look at the statement of claim for divorce, which is a commencement document, it deals with all the issues. Now, when you are married and you get separated, the main issue is the divorce judgment. However, we have what we call corollary relief. And those things are the interim issues that you have to deal with them because they came as a result of you guys being together. But that's not the main divorce. The divorce itself is a divorce judgment, which you get or you can apply for after being separated for 1 year. During that time when you're waiting for your 1 year to elapse, you have to deal with parenting if you have children and decision making. But if you don't have children, then those things don't apply to you. If you want support, you have to now deal with support. However, if you don't have children, again, you're not dealing with child support. So all circumstantial, right? If your income is high and you don't need spousal support, you never deal with it, which means you waive it because, again, it doesn't apply to you. If you don't have property, you don't have to deal with property because, again, it has to be applicable to your circumstances, which is why they are not the divorce. They are what we call the corollary relief, interim matters. So you get court orders for those to deal with them. And then at the end of the day, you get your divorce judgment to finalize the matter. So if you have been separated and you're thinking of going through the court system to deal with your separation and eventual divorce, you have to file a statement of claim for divorce. On that document, it will talk about parenting arrangement that you're proposing. It will talk about relying on the federal child support guidelines for child support calculations. It will talk about spousal support. It will talk about property. That commencement document deals with everything that you already have to talk about regarding your circumstance. But as you go through the process, they get addressed until all of them are addressed in one bulk or together. And then at the end, you get your divorce judgment. So you don't need to do separate documentations for those. Your commencement document, it carries you along. But the difference between the former system and what we have now is that you could say, I don't want to start a divorce process. I just want to go make an application for parenting order. You could do that. But people were dealing with things at different times, too many applications here and there. It was too much work. And of course, use of resources. So they tried to put structure. Put everything in your commencement document. We will take you step by step through our process until you can resolve all your interim matters, and then you get your divorce judgment.
Thank you very much.
That was
I see
beautiful.
Rita's
I
hand
think
is
Rita,
up.
yes.
Yeah.
Rita, you can ask your question now.
Yes, thank you. Hi, thank you so much for having me. Okay, so just a quick question. So in addition to the question that was already asked, I wanted to know if, first of all, I've been separated for almost a year. It's going to be a year in August.
Okay.
And I've never received any form of like child support, or I think we do have parenting arrangements in place just within ourselves. So
Okay.
it comes in like once every 2 weeks and sees the kids for 30 minutes, which is ridiculous. So I'm just hoping that I want to get like an arrangement, but it's not willing to actually begin the process of a mediation. Do you understand what I mean? So I don't know if I have to be the one to communicate that, like, or it's something that you can do, like send him an email or a mail, just like some form of something that's he doesn't have a choice. He just has to agree to the terms. So maybe we just negotiate something, because it's really stressful having to handle 2 kids by myself and job and pick up, other stuff and swimming and everything. Because I honestly just want him to be like in the kids' life. Like, I don't know why you wouldn't want to be with the kids. And also the second question is, in a situation of divorce, I've actually spoken to a couple of people who said, I think cost-wise, it's best to do it back home. I don't know if that makes any sense. Do you think it's better to do it here in Canada, or I could just do it back home?
Okay, let me start with your first question, because that is priority, is about the children. When it comes to child support, it's not a choice. Child support is the right of a child, and no parent has the right to decide on whether they want to. It's not a thing of wanting. So the wishes of the parent in this case is just a moot point, meaning that you don't have to beg him. And I'm going to tell you what to do in a situation like that. If you can afford a lawyer, get a lawyer to get you a child support order. However, you were married and you need to go through a divorce process eventually, which means that with this court system, unfortunately, you will have to like commence an action here, because they will not do a standalone application for child support. That's very hard to take, but it's true. If the lawyer is in place, what I would do in a situation like this for my client is write a very strong letter to the other side and say, provide me with your financial disclosure. I need this. We do have a template online, which is called the notice to disclose, items 1 to 16. I'm checking off the boxes that I want. I'm filing it with the court. I'm serving it on them, and they will have a month to provide me with those documents. If they don't provide me with those documents, I'm submitting a desk application for a disclosure order and asking the court to impose a $100 per day penalty for every day that they delay to provide that document to me. So you are going to make a lot of money from this person if they continue to be nonchalant. And that is not a choice to them. So you see how you remove the power from their hands and put it in nature? And so they will provide those documents. I will get your own documents. You have the children primarily, so you are the primary parent by default. They are the visiting parent. They are the only ones that are going to pay child support, Section 3. I will look at that income. If they make $100,000 a year, according to their tax filings, I'm putting it into my software and calculating how much they're paying for the number of children. And then I'm sending them a letter and saying that this is what you have to pay my client starting on this date. We are now in July. So I'm going to put starting August 1st, this is what you need to pay my client for the children every month. And then I look back onto your date of separation and the fact that they haven't paid, I calculate what they were supposed to pay you, and that forms the arrears. I will tell them in that same letter, this is how much you owe my client from the date of separation until present. You have this date to pay it. Because if you don't pay it, I'm going to bring a court action where I will get a court order against you. And guess what? If I succeed to get a court order, I will ask the court to make you pay my client cost. And Schedule C cost is very expensive. You could get up to $5,000 against this person, depending on how much delay and inconvenience they cost you. So they are going to be paying and they will take steps. It's just that you need to either address it or get someone to address it for you. But it's not a matter of choice. The second part is that before I get to the second part, I just need to say that you need to get a child support order because again, it's not your decision to get child support or not. Your children are supposed to get child support. The reason why parents have control over child support and are the ones to make that application is because the children are under the age of 18. They cannot bring an application themselves by way of lawfulness. A child who is 18 years old and still needs child support because they are going to post-secondary education can make that application themselves. So at that point, you are not needed. And if your child was if a child was in the foster care system, the foster parent can do so. And also child support, if say your parents were caring for your child as grandparents and they were the primary caregivers for your child, they can make an application for child support. You're just a medium by which child support is received, but you don't make a decision on I want it, I don't want it. You're supposed to get it for the children. The court will not grant the court will not get a divorce judgment granted without child support arrangements in place. On your second question, I can't tell you what to do or where to commence your divorce action. That's a personal decision for you based on your understanding of the Canadian system or the Nigerian system, because from your name, I'm assuming you're Nigerian. But what I would tell you is this. Your children live here. I assume they live with you here in Canada, in Alberta, in Calgary. And I believe you live here long term. So if you're deciding to subject yourself to a system where you are not living or residing in that system consistently, then you have to understand that it may not give you the same privileges that the system under which you live could provide you. Because again, if you're going through the Nigerian system, how do you deal with parenting and child support for your children here? They live here. They are subject to the protection of the Alberta province and the country of Canada. So it's not just about you, and it's not just about obtaining a divorce judgment. It's about the interim issues that you have to deal with as part of your separation. So that's what I was saying.
Thank you so much. Thank you so much. So I just want just a quick question. I know we're running out of time.
We are 5 minutes late.
5 minutes, sorry.
Yeah.
So just a quick question. So what if it's a situation whereby my separated partner is saying he hasn't earned any money in 1 year? And he wasn't making any money.
There are ways to find out. If they live in Canada, you can easily find out about someone's income.
Okay.
Yeah. If they're not providing it, again, there are ways to get that, which I just explained previously. And even if they don't provide it, you can get a court order to reach out directly to CRA.
Okay. Thank you so much.
Okay, thank you all. Thank you so much for attending today's Legal Lunch and Learn. Barrister Lucy, thank you. Thank you for always pouring the knowledge to us. We are grateful. We appreciate this great privilege. And just to reinforce everything Barrister Lucy has said, Ruth House is here to walk you through this process. We have a number of resource and systems in place and support to run you through this process. You don't have to walk alone.
Yeah.
We are here to hold your hands through. We have people like Barrister Lucy here. We have Ruth House to help you through. So if you are not so sure of what to do, you can give us a call. We can run you through the process. We'll listen to you and give you the accurate support and advice that you need through your situation. Again, everybody's situation is dynamic and different. So you have to talk to us, to talk to the right resource and make available the right platform for you to go through this process.
Yeah, I have a very brief comment for reader, because again, your situation is very common in the family court system. If someone is saying they don't have an income because maybe they've been doing under the table jobs, cash jobs, blah, 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 you might not even find that information from CRA. There is an authority that the court has to impose an income against somebody. And that is called imputation of income. You may have heard about that. You may want to read about it. Go to Google, download the Federal Child Support Guidelines, go to section 21. You will see the circumstances under which the court can apply that authority. That is an authority that the court has. They can say, based on the person's age, the previous history of earnings. So of course, if they've lived in Canada for long, they cannot be without income ever. And based on their physical capability, so they're not disabled bodily or mentally, and that level of education, all of those things, the court can say, on a fair market value, somebody of your age, education, physical strength, all of those things can make more than minimum wage. So I'm going to put your income on this number, because if you're looking for a job, this is what you could make. And they will use that number to calculate child support. And they'll give you a court order. You will take that court order to maintenance enforcement, and maintenance enforcement will get that money from that person every month. That's what I'll say to you again. Just added information, but thank you for listening.
Okay, thank you all. Thank you all. Thank you for staying extra time. We are grateful. Have a great day and enjoy yourself.
Yes. Thank you, Victoria,
Bye.
for
Thank you.
your co-hosting every time.
Right.
Thank you
And
very
I
much.
enjoyed
Bye.
this with you.
Bye.
Thank you, everybody. Bye. Yeah, hi, baby. Bye.
That's a future lawyer.
Right.